There is a recurring pattern in Nigerian politics that demands serious scrutiny. Each time a credible opposition force emerges, each time Nigerians begin to coalesce around an alternative to the APC's grip on power, something intervenes. A court case materializes, a controversy takes shape. And suddenly, instead of discussing the fact that millions of Nigerians cannot afford food, or that children are being kidnapped in states where governments pursue activists, national conversation is hijacked by courtroom technicalities. The latest episode in this familiar playbook has just been filed. The suit, what was filed and by whom? A suit has been filed at the Federal High Court in Abuja, marked FHC ABJ CS 11152026, and assigned to Justice Mohammed Yuma by one Age Ibrahim Kalahi, Director of Organization for the All Democratic Alliance ADA. The suit names INEC as the first defendant and the Nigerian Democratic Congress, NDC, as the second. Kalahi is seeking perpetual injunctions that would restrain INEC from recognizing NDC as a political party and prevent NDC from presenting itself publicly as a registered party in any medium. This is not a routine legal challenge. This is an extinction order, a demand that the NDC be erased not just from INEC's register, but from Nigeria's political landscape entirely. There is, however, an immediate contradiction at the foundation of this suit. Despite the ADA being listed as a co-plaintiff, Kalahi insists the action was filed in his personal capacity and bears no connection to the ADA. The party is literally named in the court documents, and its director is simultaneously claiming no association. That contradiction alone should raise serious questions about the integrity of this case. The 5 claims and what they omit. Kalahi's 25-paragraph affidavit rests on 5 arguments. He contends that NDC was absent from the list of pre-qualified associations for the 2025 registration exercise, that NDC did not pay the mandatory $2 million administrative fee, that NDC did not access INEC's dedicated registration portal, that NDC failed to complete Form EC-15A, and that NDC was not among the associations INEC published as having applied. These would be compelling if the full history of NDC's registration were not publicly documented. What the affidavit conspicuously omits is that NDC's registration journey did not begin in 2025. It began in *2017 ***. NDC was among the original 171 associations that applied when the process opened, and INEC formally acknowledged that application. Senator Saraki Dixon has published correspondence from March 2017 confirming this. When registration resumed in 2024, NDC revisited and updated its earlier application accordingly. When Kalahi argues that NDC bypassed every mandatory step, he is making that argument while disregarding nearly a decade of documented engagement between the party and the Commission. The court order that settled the matter INEC's stated basis for excluding NDC from the final stage of screening was that the party's logo bore a close resemblance to that of the ruling APC, a position widely regarded as without merit. NDC challenged this in court. The Federal High Court sitting in Lokoja, in suit number FHC LKG CH 492025, ruled in NDC's favor. The court found that NDC's logo was clearly distinct from the APC's and ordered INEC to register the Nigerian Democratic Congress as a political party. INEC complied. INEC did not appeal. The window for doing so has closed. The judgment is final, binding, and legally subsisting, res judicata. The question Kalahi's suit now poses is stark. What is a federal high court in Abuja being asked to do with a matter already conclusively decided by a court of coordinate jurisdiction, whose ruling was never challenged? In law, that is called forum shopping *, and Nigerian courts are not supposed to entertain it. The profound irony of the plaintiff. In September 2025, INEC cleared 14 associations, including ADA, for the registration exercise. ADA progressed through the process, paying its fees and uploading required documentation. When INEC completed its final review in February 2026, only one association, the DLA, met all legal requirements and was formally registered. ADA did not make it through. ADA subsequently filed its own suit against INEC. That case was dismissed by the Federal High Court in Abuja, not on the merits, but because it was procedurally defective. The All Democratic Alliance, unregistered, and whose own legal challenge was struck out for procedural incompetence, is now pursuing a case in which it argues that NDC's registration was procedurally defective. ADA is still fighting for its own existence, and yet has found time to seek the annihilation of a party that succeeded where it failed. This is a grievance-driven lawsuit in its most transparent form. What this is really about. The NDC is not being targeted because of procedural concerns. It is being targeted because it is the platform that Peter Obi and Rabiu Kwankwaso have adopted for the 2027 presidential race. It is the party around which millions of Nigerians seeking genuine political change are organizing. It is developing an independent result transmission system and has been building grassroots infrastructure at a pace that has clearly alarmed certain interests. The timing is not coincidental. This suit has arrived precisely as NDC is consolidating its 2027 campaign architecture. Those who cannot defeat NDC at the ballot box are reaching for the courtroom, betting that sustained legal distraction will drain the party's energy and introduce doubt among supporters. What NDC must do. The facts are firmly on NDC's side. The party has a documented 8-year registration history, a final unappealed court judgment in its favor, and INEC's own compliance as the clearest endorsement of its legitimacy. NDC's legal team should file a preliminary objection immediately, invoking res judicata and raising forum shopping as a threshold issue. Any court of sound jurisprudence should strike this suit out at the preliminary stage without examining the merits. Beyond the courtroom, the party must not lose a single working day to this distraction. Polling unit agents must be trained. The independent result transmission system must be deployed. The millions of Nigerians waiting for meaningful change must not be kept waiting because a non-registered party decided to try its luck in an Abuja courtroom. The legal challenge is manageable. The mission must continue.